Hello, everyone. We're going to wait a minute or so just to make sure we have people here. Hello, everyone. All right, we're going to go ahead and get started. I think we're good to start. So thank you everyone for being here and joining our community conversation with State Attorney Monique Worrell. My name is Kat Periel, and I am the Campaign for Justice organizer here at the ACLU of Florida. And so just before we start, we're going to do some quick introductions. And so firstly, once again, we're thrilled to have State Attorney Monique Worrell here with us today to speak with us about criminal justice reforms. State Attorney Worrell serves as the Ninth Judicial Circuit, representing both Orange and Osceola counties. Previously, she was a clinical law professor at the University of Florida College of Law and founding director of the university's Criminal Justice Center. She was also the founding director of the Conviction Integrity Unit of the State Attorney's Office in Orange County. She was elected in 2020 in the hopes of bringing much needed changes to our fundamentally flawed criminal legal system. And facilitating our discussion tonight is Ms. Melba Pearson, the Policy Director for Florida International University's Center for the Administration of Justice, and formerly the Deputy Director of the ACLU of Florida. Melba also served as a prosecutor in Miami-Dade County for several years. Just to preface, toward the end of the hour, we will take questions from the public. So please be sure to put your questions in the chat. And now I will turn it over to Melba to facilitate our discussion. You can take it away.
Great. Thank you so much, Kat. And good afternoon, everyone. Good afternoon, ACLU family. Again, my name is Melba Pearson, and I'm really looking forward to this discussion this evening with State Attorney Monique Worrell. Again, another reminder to please put your comments, questions, thoughts in the chat. We are definitely going to be engaging around the concerns that the community has around, how this is going, how to hold our electeds accountable, and how to make sure that we bring real and sustained change in criminal justice reform to our system. So the bigger context around this discussion is looking at the issue of mass incarceration in Florida. We know that unfortunately Florida keeps people incarcerated for way too long, and too many people are being incarcerated. We have heard the horror stories that people who are incarcerated endure here in the state, whether it be systemic sexual assaults in Lowell as well as Coleman prisons, to people just dying in police custody in the jails and in the prisons. So these are all concerns that I know are very top of mind for many people. So that's why it was really important to have this discussion. We've also learned through the use of data and various reports and research techniques that racial disparities exist at every stage of the process, whether it be arrest, charging, pleas, and sentence length. I encourage everyone to look at the ACLU reports around these issues. They still live on the ACLU of Florida's website, so you can learn more about the data and the problems that have been documented with the criminal justice system here in Florida. And another issue that has been of massive concern is that of pretrial detention and of people simply being locked up before trial, not because they pose a danger to the community, but because they don't have enough money in their bank account to be able to pay for their bail or their bond, through either posting everything up front themselves or contracting with a bail bondsman. So there's so many issues with regards to that, because if we call ourselves a country of innocent until proven guilty, then why are you treating someone as if they're already guilty before they've even been able to present their case. At the end of the day, public safety is critical. We all want to be safe in our homes and in our beds. We all want to feel protected, but are we really keeping our community safe, or are we just churning out more failed policies just because it plays well in the media and that's what people want to hear? Are we really pushing forward change and making sure that the system is equitable for everyone? And how do we go about those changes? So these are all the things that are in the background that have fueled some of the questions that we'll be asking State Attorney Worrell today. And so turning to you, State Attorney, during your campaign, you were asked a number of questions with regards to your stances on these issues, whether it be transparency around prosecutorial decisions, addressing racial disparities. So at this juncture, we wanted to check in with you, see how things were going, and really hear about the reforms that you've been able to put in place, as well as your plans for the future, keeping in mind that I believe this is your 8th month in office. So we know Rome was not built in a day. We know that we didn't get to these issues overnight, and that they're not going to be resolved overnight. It's going to take time and deliberate efforts to be able to fix that. So, just getting right to it, let's get into the discussion and talk about bail reform. We know that this is a confusing topic for a lot of folks. So can you explain to everybody watching how decisions on monetary bail are made in your office, and what your office is doing to make sure that people aren't being held pretrial just because they don't have enough money in their pocket?
Sure. Well, first, good evening to everyone, to the ACLU family. It is an honor and a privilege for me to be back before you all this evening. And of course, to my esteemed colleague, Melba Pearson, it is wonderful to share the screen with you yet again. As it relates to bail in the Ninth Judicial Circuit, there's currently an administrative order that governs the bond schedule, as well as a bond policy that was enacted under the Ayala administration. My assistant state attorneys argue first and foremost for pretrial release if the individual qualifies and the facts of the case are appropriate. My jurisdiction has the ability to do pretrial release without having to post bond, or pretrial release in addition to bond. So there's 2 options where that's concerned. And based on the facts of the case and the history of the accused, we argue for pretrial diversion. For every case that comes through initial appearance, we get a first appearance information sheet that has whether or not the individual would qualify for pretrial diversion, as well as their criminal history. Factors that we use to determine what is argued are: what are the facts of the individual case, what is the criminal history of the accused, and whether or not they're a danger or a risk to the community, any pending cases or other bond supervision. And we also take into account what the victim in the case feels about the individual's release. So there are several factors that we take into place, but it's important for everyone to understand that the state attorney's office is not the only deciding factor, that there is an administrative order from the court regarding the bond schedule, and ultimately the judges make the decision as to whether or not an individual will receive a bond.
And so just to following up in that vein, have you brought into play any new policies around bail and pretrial release, or, are there other changes that are in the future you're planning on making in the future that you can talk about?
Sure. So we argue for pretrial release, even when the information sheet that I mentioned earlier says that the individual doesn't qualify, because ultimately the judge has the final say and can order that even when an individual doesn't qualify. Also, as most of the community is aware, that I've implemented a community health and safety plan that was a response to the COVID outbreak in the jails. And I know we'll talk about this a little bit more later, but based on the current situation with the COVID-19 virus, I personally believe that jail is not the best place for people to be awaiting trial. So we argue for people to be out on bonds or pretrial release, and for bonds not to be revoked for less serious charges or incidents.
Wonderful, wonderful. So turning now to the topic of probation. So, we've heard a ton of horror stories around people who have been arrested and incarcerated for low-level nonviolent offenses. And we know that this is a waste of taxpayer dollars. We know that it's stretching our criminal justice resources when it needs to be focused on other key issues in our communities. So you had discussed in your candidate questionnaire while you were on the campaign trail, you discussed adopting a policy of recommending that a person be released on their own recognizance for property and drug-related misdemeanor offenses and technical violations of probation. So can you kind of break that down a little bit and talk about why this is important and what your office is doing to make sure that the jail is a place that is only reserved for people who truly need to be separated from the community, and that people aren't being incarcerated for lower level and technical violations that basically comes out of the taxpayer's pocket?
Sure. So it's basically a review of a totality of circumstances. When a member of our community is arrested, there are many consequences that flow from that event. Oftentimes there are missed days at work, and they have a cascading effect, such as loss of work, inability to pay bills, and in some cases, loss of housing or loss of children. So before we decide to inflict this upon members of the society, we want to be sure that we're taking appropriate measures to address the alleged offense. This determination is based on considering whether the accused poses a threat to the community in light of the offense that is alleged, and their criminal history. For those charged with property crimes or drug offenses that don't involve allegations of violence, my office has determined that there are better community-based supervision options that can simultaneously give courts, the community, the family of the accused, the assurances that they will appear for court and not pose a danger to the community. So what we do is we're taking measures to ensure that those awaiting trial on misdemeanor charges have the ability to post a reasonable bond or the ability to be released on their own recognizance with minimal conditions of supervision, unless there's any indication that their release would pose a danger to the society. For example, their misdemeanor arrests constituted a significant violation of the condition of release prior to their offense. But ultimately, our goal is ensuring the safety of the community. And if pretrial detention does not further the safety of the community, then there's no purpose in doing it.
Yeah, absolutely. So then, turning to one statistic, looking at this past June of 2021, the Orange County Jail had 244 people waiting for trial on misdemeanor offenses. What can your office do to make sure that people aren't locked up in jail while awaiting trial on misdemeanor charges?
So again, I want to preface the question by saying that the state attorney's office is only one factor in the determination of pretrial release. So what happens for us at initial appearance and bond hearings, we will argue for non-incarceration. However, there's many factors that play a part in whether or not someone would remain in custody. Some individuals have failed to appear or violated previous release conditions. That is going to make it more likely that they will be ordered to stay in custody. Others might have violations of probation for misdemeanor cases, but the violations are serious felony charges, or people who are on felony probation and the new law violation is a misdemeanor case. So it's difficult to look at the numbers without being able to put them in context. Sometimes there are individuals who we've made an offer to and they've refused the plea offer. That could have them staying in custody. We always, by matter of policy, will request from the court the least restrictive pretrial means that keep the community safe and also ensure the accused appearance at future court dates. That is our policy. The court ultimately is going to make the decision on what should happen.
So let's shift gears to COVID. So that has really, to be blunt, has really messed up the last 2 years, right? Just as a general premise. But now we have the Delta variant, which has been spreading at a faster rate and has been much more dangerous than the original iteration of COVID that we had seen previously. And as we know, it is completely impossible to socially distance within a jail setting because everything is in close quarters, and the level of sanitation that needs to happen, cleaning the areas and washing sheets and all that, just literally is not happening in the jail, especially when you get into the aspect of it being overcrowded. So first of all, we want to thank you for your leadership with the COVID health and safety policy you implemented during your first few months in office. But can you tell us a little bit more about the changes you made to address COVID in jails and keep those incarcerated and those working in our jails safe, with the proviso that obviously the jails are not run by the state attorney's office. They're run by, the Department of Corrections or the local sheriff, depending on where you are located. But what is within your power to do, and what have you done with regards to the issue of COVID in the jail system?
Yeah, so what I want to say with that is, within my first 30 days in office, my team put together and implemented the community health and safety plan. And that was specifically geared towards an outbreak that was happening of COVID-19 in the Orange County Jail as I took office. And currently we're experiencing an outbreak of COVID-19 in the Osceola County Jail 8 months later. So we know that our COVID conditions are very similar to what they were a year ago. The purpose of that policy was to encourage assistant state attorneys to be more mindful, not only of pretrial detention, because overall there's a policy that's presumptive of not detaining someone pretrial unless they're a danger to the community, but also in plea negotiations, determining whether or not incarceration is necessary, understanding that incarcerated people are, I believe, 4 times as likely to contract COVID-19 and twice as likely to die from COVID-19. In addition to the fact that individuals who are in the county jails will then be released back into the community, carrying COVID-19 back into the community, as well as the fact that there are individuals who are employed within the county jails who are then able to contract the virus and carry it back into the community. So all around, the incarcerating has contributed to the rise in COVID-19 numbers here locally in the 9th Judicial Circuit. So the community health and safety plan was geared towards being very mindful as whether or not incarceration as a tool is necessary, and whether or not there are alternatives to incarceration that would be appropriate as sanctions in dealing with these cases. So the question, I think, is, well, now with COVID-19 variant ramping up, what are we going to do differently? And my answer to that is nothing, because the policy that we put in place for COVID-19 was based on a deadly, dangerous, and contagious disease. And that policy would apply as well to the Delta variant, that we should not be advocating for people to be detained under these circumstances, because no one should receive a death sentence for something that does not pose a danger to the community. So we need to really be mindful when we're engaging in plea negotiations as to whether or not the risk of death is worth whatever the sentence is that we're asking for.
Yeah, absolutely. So now let's talk a little bit about pregnant individuals in the jail and prison system. So, one thing I think is a point of agreement for everyone, that it's inhumane and super dangerous to a person and the survival of their newborn to force them to go through labor and childbirth alone in a jail cell. But it's something we keep seeing happen over and over again in the state of Florida. The Tammy Jackson bill was signed into law by the legislature and the governor in 2020 in response to a woman, Tammy Jackson, who gave birth by herself in a Broward County jail. And now, a week ago, we pretty much saw the same thing happen in Alachua County, where a woman was forced to give birth alone in her jail cell and her baby didn't survive. So, within the purview of your power as state attorney, what policies and practices do you have in place to prevent the incarceration of individuals who are pregnant? And more broadly, how can this issue be addressed within your power as state attorney?
Yeah, so the cases that you've described are absolutely tragic and should not ever happen to anyone. And, as you mentioned at the very beginning, the state attorney's power to influence these outcomes is limited in that we can only make recommendations. It's ultimately up to the judiciary to determine what will happen to an individual. And then it's further up to the Department of Corrections to determine what will happen to an individual once they've been sentenced into their custody. So, as with all cases, my assistant state attorneys are required to look at mitigating factors. And mitigating factors would be obviously whether or not someone is ready to give birth, in addition to whether or not someone is a primary caregiver. This is all mitigation that needs to be taken into consideration when we are fashioning either a plea negotiation or a pretrial detention determination. Those are all mitigation factors that have to be taken into consideration.
And staying with that, let's talk a little bit about people that are primary caregivers. One thing's for sure, we are doing a disservice to our communities and to those who are most vulnerable, minor children and elderly parents, by incarcerating people who are the ones responsible for giving them their care and protecting them. And we all know that when vulnerable individuals are left to their own devices, they are at a higher risk for abuse and at a higher risk for encountering the system and not in a positive manner. So many times we see, mothers and fathers, parents who are innocent, accepting a plea deal and admitting guilt to either a lesser charge or to the charges as they stand, just to be able to get back home to their families. So let's dive into that a little bit. What is your office doing to ensure that primary caregivers of minor children and elderly adults are provided with options that don't include incarceration and they're not forced to accept a plea in order to get back home? And then following up on that, do you have a specific policy that would prevent primary caregivers from being detained pre-trial unless absolutely necessary? So can you break that down a little bit?
Sure. So as a defense attorney for 20 years, I am acutely aware of the decisions that people have to make with regard to whether or not they should enter a plea, regardless of their guilt or innocence, but so that the system has the least possible impact on their lives. So of course, that was a consideration for me in becoming state attorney. And I'm very pleased to announce that I have created a role where we now have a diversion unit that has a director who's responsible for developing and implementing diversion programs. We're going to have pre-filing diversion that's going to be available within a matter of weeks, as well as post-filing diversion. And one of the things that this does is it limits, and as I said in my opening, when we appear at initial appearance, we are immediately looking at, is this person eligible for diversion? Can we go ahead and divert this individual now so that we don't have, one, for them to have to come back to court at all, all right? And two, to resolve the case so that they do not have to deal with pretrial detention. And if the case is not diverted at that point, there are many junctures going down the line at which someone can have their case diverted. So we are expanding diversion programs. We are expanding opportunities for diversion, and take that very seriously as a part of our community engagement responsibility to educate the community. Because there are a lot of things that happen where people get arrested and they are charged with offenses that have to do with lack of education. One of them that I'll bring to your attention is resisting without violence. A lot of people believe that you have to be under arrest to be charged with resisting. But those of us in the legal community understand that that is not the case. You do not have to be under arrest to be charged with resisting. So simply educating an individual who is arrested for resisting on what their rights and responsibilities are as a citizen in the Ninth Judicial Circuit will stop the person from having a reoccurrence of this event, but will also not require them to be, dragged through the whole criminal legal system.
And if you could, I know you touched on it in your answer, but can you talk about why diversion is such an important tool and how that kind of can serve as an equalizer in some ways in our system, but of course, with the caveat, it doesn't cure everything.
Right. So diversion is extremely important because when cases are diverted, that means that they are no longer in the criminal legal system. That means that you are no longer at risk of obtaining a conviction. A conviction on someone's record is the difference between getting a job or not getting a job, getting housing or not getting housing, getting accepted into a college or not getting accepted into a college, and so many other things. So by saving someone from having a conviction on their record, literally can determine the trajectory of their life. Because I've seen individuals who've been convicted when they didn't even understand what the conviction meant. And then years later, they went to apply for jobs and they were denied that opportunity because this conviction was on their record. Years later, they went to apply for housing and they were denied housing because they had the conviction on their record. So, you said the word equalize, it does, because there are so many individuals who their entire futures are thrown away because of a mistake, because of an indiscretion, because of something that should not cost them their entire future and their entire career.
And what are some of the things that people do in diversion, especially in your circuit? What sorts of, what does a diversion program really look like? What's the nuts and bolts?
So there are many different diversion programs. I'm proud to say we have a resisting diversion program that addresses the law around what law enforcement has a right to do and why you would be charged with resisting if you don't comply when you're asked to do something that they ask you to do. We have a prostitution diversion program to combat human trafficking, where we are not, targeting the prosecution of sex work, but rather helping people to get their lives on track and, do something else. We are looking at driving diversion programs. There are gun diversion programs. There are drug diversion programs. So one of the things that I'm really proud to say is that we have created an abundance of programs that address different things where, individuals can get their lives together without being involved in the criminal legal system. We've broadened diversion policies to include individuals regardless of their immigration status. So undocumented immigrants are now eligible for the diversion program. So just really exciting, some of the things that we've been able to come up with in such a short period of time.
And, just to also put a finer point on it, when someone goes to a diversion program, that can include, classes or counseling, therapy, those sorts of things, right?
Correct. So classes, education, as I mentioned, is tantamount, but there could also be assistance for mental health services. There could be assistance for parenting. There could be assistance for, drugs. Whatever the particular circumstances are going to be very specific to the type of diversion that is recommended.
Great, great. So then turning to admissions of guilt, does your office require an admission of guilt in order to receive a civil citation or any other pre-arrest diversion referral instead of being arrested?
So currently in the Ninth Circuit, we only have juvenile pre-arrest civil citations that are processed in our circuit. We are working actively with the local law enforcement and the mayor's office to create a process for adults, but there's only formally a civil citation for juveniles.
And what are some of the as a general premise, not, kind of like just to highlight why this can be problematic, what are some of the collateral consequences that can come from giving an admission of guilt, especially that early in the process? Like, in order to, not be arrested, you have to admit to pleading guilty. Like, what are some of the consequences that can come from that?
Yeah, this is important because it was a huge factor when we went into considering whether or not individuals should be allowed to plea at initial appearance. Because sure, it would help us in not having people incarcerated that shouldn't be incarcerated. But the detriment to that is by then they've not had an opportunity to consult with counsel. They don't know how good the case against them is or isn't. They aren't aware of what the defenses to them are. There could be collateral consequences that come as a result of an admission of guilt prior to consulting with counsel. So there's so many reasons why it's bad to obtain admissions from individuals prior to them having the opportunity to exercise their legal right to counsel. We have to think of, why is there a legal right to counsel? Why is one of the premises of our system that you have the right to an attorney, and if you cannot afford one, one will be appointed to you? It's because it's a very important legal right. And obtaining admissions from individuals to ensure that they're not arrested, it just smells wrong all the way, right? Because then you'll have admissions that aren't necessarily admissions, but they're coerced statements that are made to avoid incarceration. And we don't want that.
Yeah, that coercion part is definitely key. And of course, not understanding, that there may be a viable defense, or that, you can take a different approach, as opposed to now you're pigeonholed because you've pled guilty and all the collateral consequences that come with that. So yeah, definitely need to highlight the dangers around that. So turning to racial disparities. So as we were talking about before, we know that racial disparities exist at every stage of our criminal justice process, whether it be which neighborhoods get policed and on what scale, who gets arrested for marijuana and who doesn't, thinking through other low-level offenses and what consequences look like for different groups of people, charges, plea offers, pretrial, and sentence length. So knowing all of this, what are some specific steps that your office has taken in order to address racial disparities and make sure that everyone is treated equally, no matter your skin color or what part of town you're from or what your ethnicity is or how you identify?
Yeah. So I believe that the best way to address racial disparities in the criminal legal system is to begin by acknowledging that these disparities exist, that they are real, and then taking steps to reduce them. My administration has made diversity in recruitment and hiring a top priority in order to expand the diversity and perspective in our decision-making process. We're also hiring a data analyst to assist us in understanding the impact that our decisions have on either increasing or decreasing the disparities that exist in the Ninth Judicial Circuit. And I say that exists because I know they exist because I researched them when I was running for state attorney. So the hiring of the data analyst is not to determine whether or not these disparities exist here, but rather the things that we're doing, how are they working towards increasing or decreasing those disparities? And as you know, we have partnered with you and FIU on the Prosecutorial Performance Indicators Program, which is also geared towards measuring racial disparities in our practice.
Yeah, we're definitely thrilled to have you as a partner, along with State Attorney Harold Pryor in Broward, who we'll be, hearing from in a couple of weeks, and a number of other offices across the country from all the different parts of the political spectrum who see the importance of data and transparency and being accountable to the voters, the people, the community, the people that they serve. So thank you so much for that, State Attorney Worrell. So now let's talk about the hot topic of policing and police accountability. Not a whole lot of lead up needs to be done on that. I mean, we all saw the summer of racial reckoning that was basically last summer. We've seen so many high profile cases and the difference that a DA or a state attorney makes when they're, really centering the police accountability. So what is your office doing to ensure that police who engage in excessive use of force are held accountable for their actions? And I'm going to broaden that slightly to talk about the prison context as well. If there's anything that could be done from your perspective to address, either jail or prison guards who act in an inappropriate manner towards the people that are in their care.
Yeah. So first, it's important to note that there is no charge for excessive use of force. I want to say that again. There is no charge. There's no law that is currently on the books by which a prosecutor can charge a law enforcement officer with excessive use of force. There is a statute that governs use of force by law enforcement officers. But what that is prescribing when officers may use force. It doesn't define excessive force. It doesn't say what force is not permissible, but it says basically law enforcement officers may use force, including deadly force, when conducting an arrest, when pursuing a fleeing felon, or pursuing an escaped convict. So when state attorneys and district attorneys throughout the country prosecute law enforcement officers, they're not prosecuting them for excessive use of force. They're prosecuting them for whatever the crime was that occurred as a result of that excessive use of force that falls outside of the statutory use of force requirement. So I created an officer-involved critical incident team and policy. The team implements the policy for reviewing officer-involved critical incidents. And this was basically geared towards dealing with the public's perception of transparency and accountability in law enforcement investigations, and that when there's complex and difficult investigations involving officer-involved critical incidents resulting in injury or death, that best practices dictate that these investigations should be performed by an agency that's separate and independent from the agency where the officer is employed. So here in the Ninth Circuit, the Florida Department of Law Enforcement is the agency that is tasked with conducting those investigations. However, the state attorney has now joined in being a part of those investigations, and that in the event that there is additional investigation that is needed after the FDLE investigation is complete, we will review their investigation and then conduct any supplemental investigation that is necessary. In that, we make determinations on whether or not an officer has abused their discretion within the law of use of force, and whether or not a prosecution is warranted as a result of that. But I cannot overstate the importance of understanding that there are many protections within the law for law enforcement officers in using force, many more than I had even conceived of before becoming state attorney. So it's really important for the public to understand that when you see a prosecutor come forward and bring a law enforcement officer to trial for excessive use of force or for violating the law as a result of their excessive use of force, it's a big deal because the law is not conducive to bringing such charges.
Yeah, for sure. And, just to put a finer point on that, we all saw with the Derek Chauvin trial for his murder of George Floyd that the whole debate was what level of murder is appropriate here. Should it be first degree, second degree, third degree, and the jury ended up coming back with a verdict of second degree and third degree murder. But again, that's the charge. It's not he was charged with excessive use of force. He was charged with homicide. He was charged with murder. So that's a really important distinction that I think sometimes folks don't always see.
And something that's really important to note about what happened with the Derek Chauvin case that I believe could have turned out completely differently was that we had a video, a very clear and present video that showed every single second of what took place. Often what happens in these cases is that the video is not clear, the video is encumbered, or there is need for a witness to, corroborate what has taken place. And when the only witness is dead, then there's no one else there to tell the other side of the story. So these cases are very complex, and it's just really important for people to understand that, you can't just charge someone because you think that a situation was wrong. We can be upset and we can agree that an injustice has occurred, but the way our legal system is set up, we can't just charge people because we didn't like what happened. We actually have to have a legal basis to bring charges. And when it happens, I believe that you will see that happen, but it is less likely than people believe.
And so 2 more points that I want to make on this topic before moving to the next one is, first of all, and I know the ACLU is going to keep everyone informed on this, but in the next legislative session, there is a bill that is going to be introduced. I believe it's HB 11 that is going to make it harder for civilians to videotape the police, right? So think about, that brave young woman, I believe she was 17 years old, who stood there and filmed George Floyd being murdered and, basically put her own mental health and safety aside to make sure that this entire incident was documented. And this was the video that played a critical role in the trial. The Florida legislature is now trying to make it harder for civilians to videotape the police. They're now saying that there has to be 30 feet between the officer and the person that's taping. And it's like, okay, but who's really out there with their tape measure, right? And we saw how this kind of played out in a very disturbing way in Miami Beach when there were a number of people arrested by police officers. And in one incident, the police officer kicked the handcuffed person in the head while they were cooperating, laying face down on the ground. And then someone was there videotaping. The cops turned around and attacked the person that was videotaping, threw him to the ground, and arrested him as well. As a result, the Miami Beach Police, as well as the commission, decided to suspend the ordinance that was in place that the Florida legislature is now trying to model this piece of law after. Basically, in Miami Beach, there is a 20-foot restriction for filming police officers, and that only came into play earlier this year. So, definitely want to, highlight that for everyone, that it's important to stay vigilant because these are the issues that play into prosecutors not being able to move forward because they don't have sufficient evidence. And now it seems like there's an attack to take away that last option of getting evidence, which would be that independent cell phone footage. So there's that aspect. And then secondly, as we talk about the fact that there is no statute or law governing excessive use of force, right? We really need to be advocating, and this is Melba Pearson talking independently, not affiliated with anyone, but we need to be looking real deep at who we are electing as legislators.
Thank you, because that's exactly what I was about to say. This is a time that civic engagement is probably more important, I won't say than any other time, because as a people, we have had a history of the need for civic engagement to fight for one right or another. But I will say that in this current time, civic engagement is extremely important and extremely necessary, because if we are asleep at the wheel and we continue to allow these statutes to pass or allow these bills to pass that make it more difficult to hold law enforcement officers accountable for misconduct, we cannot be upset with the state attorneys. And I'm not just saying this because I'm a state attorney. I'm saying this because sitting here, I too, when not sitting in this seat, would have believed that, oh, it's simple, just charge the person, just charge the person. And what I need the public to understand is it's not that simple, that there has to be a legal basis, that there has to be evidence in which you bring charges against someone. And if you do not have evidence, you cannot legally or ethically bring charges. So it is incumbent upon the citizens of each community to hold their legislators responsible for ensuring that there is fairness and that there is transparency when we are dealing with holding individuals accountable for their acts against the community.
So as we kind of get to the twilight of of this session, are there any other reforms that you have implemented that we haven't mentioned or touched on? Any other things that the public should know that you're working on?
Sure. So we most recently passed our Brady Policy, and the Brady Policy is basically based on our responsibility to advise individuals if we have a witness who has a credibility issue. And we have created levels. There are 3 levels of Brady, whether or not an individual has something that has happened that puts their credibility in question, but we'll still call them as a witness because it's not related to the truthfulness or their veracity. Brady level 2, it puts us in a position where, okay, we do have some concerns about their truthfulness, so we will not let them testify uncorroborated. And then level 3, where there are such serious concerns about this individual's credibility that we will not call them as a witness at all, but for extenuating circumstances. And I think that this is incumbent upon us as prosecutors to ensure that we have credible witnesses when we're bringing cases, particularly when someone's life is in our hands, their life is in the balance. We need to ensure that we have effectiveness in the witnesses that we're bringing forward. So the goal here was to outline how we will resolve our Brady obligations in a way that will create trust within the community and across state agencies to ensure uniformity in our application of the law. I mentioned the prostitution diversion program, so I won't talk about that again, but we also have made strides towards decriminalizing homelessness and transient indigent initiative. We're working with ASAs to identify community partners who will be able to assist in transient and indigent individuals. And our goal is to roundtable this process with community stakeholders to identify diversion programs that will ensure that we're not criminalizing homelessness. And then finally, I am very proud to announce that I've recently hired an individual who is not only an attorney, but also has a master's degree in mental health, who will be running our mental health unit, a newly created and formed mental health unit to deal with individuals who have mental health problems so that we are not criminalizing mental illness as well.
And with that, any final words that you want to share with everyone before I turn this over to Kat?
Just that, again, it is an absolute pleasure to come back before you all a year later, essentially, and kind of fill you in on where we are. And just please be patient. You know, our system is very deep-seated and entrenched, and making change is going to take time. And I know that many people have suffered at the hands of this system, and they want to see change yesterday. And I want to see change yesterday too. However, the reality of it is, it takes policies, it takes individuals. And I've spent the last 8 months creating policy and hiring people who will help me to change the culture of prosecution here in the Ninth Circuit. So this is just month 8. It's not even year 1. And I've got 3 years left on this term to bring to pass many of the things that I promised, and I intend to keep those promises. So thank you so much for having me.
Great. And it was amazing to be in discussion with you. Pat, I'm turning it over to you for our Q&A section.
Hello, everyone. I'm glad to be back. I want to say that listening to your answers in these questions, it was extremely enlightening. So thank you so much for taking the time to do this. We had quite a few questions come in, but we don't have, the most time available. And so we are going to answer as many questions as we can. And then any questions that we don't get to, we have taken note of them. And so we will address them in the future. And so these questions are open to both of you. So Melba and State Attorney Worrell, you both can feel free to answer. And so the first one has to do with the Tammy Jackson Act. And so is there a possibility of hiring an independent investigator to make sure that there isn't a violation of the Tammy Jackson Act?
So probably a little, sorry, go ahead.
No, go ahead, Melba, because that was very difficult to answer. Yeah.
Yeah, because just to get some clarity, because who would be the one doing the hiring, right? So an individual prosecutor's office wouldn't be hiring an independent investigator from that standpoint, but that to me sounds almost like a Department of Justice type investigation where they come in and will do a full investigation and then do what's called a consent decree, where they basically have a monitor overseeing the jail or the police department, whatever the case may be, to make sure that they're implementing reforms. So there's that angle. And, the feds can act at any time. So, that's something that's always on the table. The only other entity, because generally, who investigates our jails? Usually it's the FDLE, or it might be the local sheriff's department or sheriff's office, police department, where the jail or the prison is located. So they have the capability of investigating whether or not, there was a violation of the Tammy Jackson Act. But then again, I don't know that there was necessarily criminal penalties attached to it. It was kind of a list of things like, don't do this, don't do that, don't do the other, make sure that everybody has care and this and that. But I don't recall a penalty section where if you fail to implement these things, then the sentence is X, So I think the implementation aspect is where, the devil's always in the details. So as we move forward in this legislative session, in the wake of what happened to Ava, who's the child that passed away, and Heaven, her mother, there is appetite, I think, among some of the legislators to revisit it and maybe implement more stronger, teeth into that actual bill. But State Attorney Worrell, if you have, that's just sort of my 30,000 foot view thoughts, but.
No, thank you. I appreciate that, because I think it's important for people to understand that there are certain things that are outside the purview of the state attorney, and that would be one of them. We don't, our primary function is not to investigate crime. Our primary function is to prosecute cases brought to us by different law enforcement agencies. In the context of officer-involved critical incidents, we conduct supplemental investigations to those conducted by other agencies. So the state attorney's office doesn't investigate crime.
Thank you. So the next question, who is in charge of recommending someone for diversion in Florida? And is that the state attorney or the U.S. attorney?
So each circuit has their own policies with regard to diversion. And in the Ninth Circuit, our office makes determinations on whether or not someone should get diversion.
Thank you. And this last question, I'm going to go ahead and answer. So I'll preface by saying that. So the question was, I am very concerned about our high level of incarceration. I'm willing to volunteer to assist, but not trained in legal issues. Who should I contact? How can I help? And so for that, I would say, please get involved with the ACLU. We have plenty of volunteer opportunities and trainings, and we will be dropping the link into the comments so that you can sign up in order to become a volunteer if you're interested. But with that, if there's anything else that either of you would like to say, feel free to share now as we come to an end.
I just ask that, to stay informed on what's going on with the Office of the State Attorney. We have a Facebook page, which is Office of the Ninth Circuit State Attorney. We're also on Instagram and we're on Twitter. So stay connected with us so that you can know the things that we're working on. We have developed a community engagement committee that basically is from members of the community. So we want to hear from you. We want to hear the things that you want answers on, the things that you want to see addressed. And the only way that we can get those things is from your involvement. So please stay connected and stay involved.
And I would echo the same sentiments. First of all, thank you all for giving me the opportunity to moderate the discussion and to be in this space. But also just a reminder to folks to stay informed and each one teach one, right? Because the only way we're going to get that sustained change is when, you're coming to a reputable source to learn about an issue, and then you share that information with people in your circle. Right? Because again, if people aren't informed, they can't make the right decisions at the ballot box. And we're going to keep having the same discussion over and over again because we won't see the change that we really seek. So stay engaged, stay woke, and share that information with your circle.
Once again, I'm going to thank you both for being here with us today. And if any of you guys are interested, we will be having another community conversation September 15th with State Attorney Harold Pryor. And that link, if you'd like to sign up, is also in the comment section. So once again, thank you so much to everyone who joined us this evening. I hope that you were able to learn a little bit and get some more information. And we look forward to you going ahead and joining us in the fight for criminal justice reform.